Good morning, Europe. Good afternoon, Asia. We are here to present you a webinar about the protection of intellectual property in the software industry, co-organized by the China and Southeast Asia IPR SME Help Desk. I am Marta Bettinazzi, and I am the IP Business Advisor for the Southeast Asia Help Desk, and today I will be your moderator. First of all, let me quickly go through the screen, the interaction tools that you can see on your right. The most important feature is the question and the chat spaces, where you can post all your, again, your question, your curiosity, and everything you want to address us as the organizer or the speakers. At the end of the presentation, there will be a Q&A section, and you are welcome to ask any question before the Q&A, during the Q&A, and after the webinar. If you still have some doubts, you can write to us. You will find our webinar, the recording, on our website, both China and Southeast Asia website, in the upcoming days. So let's talk briefly about the help desk. Both the help desk, the China and the Southeast Asia help desk, have an inquiry helpline. You can write to us with all your questions regarding the protection of intellectual property in the respective region. We organize webinars, like you probably already know, since this is one of our webinars, but also we organize in-person training, and on the respective website you will find the guides and the fact sheets regarding the countries and all the other information. But please feel free to contact us anytime. We answer in 3 working days. So we no other further ado, let me introduce the first speaker of today. Is Mr. Erik Rodenbach, who is the program coordinator of ITEA 3, and he will introduce the project to you. So please, Mr. Rodenbach, the floor is yours.
Okay, thank you very much. I hope you can hear me now.
Yes.
Okay, thank you. So yes, I'm Erik Rodenbach, and I'm the ITEA program coordinator. If you have any questions later on, you can see here my email address, so you can post your questions to me after that. Okay, please, next slide. Yeah. So ITEA 3 is a sub-program, a cluster as we call it, of the EUREKA umbrella. And ITEA specifically is on software innovation. ITEA is an 8-year program. So, and the 3 means that we are already in the 3rd iteration of ITEA. And last year we had even our 20 years anniversary. Just to give you an idea, where is EUREKA and ITEA positioned in the landscape of Europe and all the funding mechanisms. You see on the upper left side, you see the 3 main programs on innovation and in cooperation in Europe. First of all, on the left side, you see the national organization, the national programs. In these programs, normally projects are created with only national partners, and they are funded by the national organizations. On the other side, you see the European program, the Horizon 2020, and in this program, there is international cooperation, of course, from European member states, and the partners there are funded by the European Commission. So EUREKA is an organization or a program which is more in the middle of this. EUREKA is also an international cooperative program. including a number of cluster programs on different topics, and ITEA is one of them. We are more on software innovation. The difference here is that the projects which are running under EUREKA and under ITEA are not funded by the European organization, but by the national organizations. So if you are a partner in EUREKA, you can get your funding from your national organizations. EUREKA was first of all started as a more European-oriented organization. However, during the years now, it evolved into a more global organization and network, I should say even. So yeah, most of the European countries are still involved in this EUREKA network, but also including Turkey, for instance, and Israel. Already some time now also we have associated countries, which are, for instance, North Korea, South Africa, Canada, Chile. So these are countries which are joining also the EUREKA network and also provide their partners from those countries with national funding if they participate in for instance, an ITEA project. So you can see it's this IPR issue, which is the discussion of today, is really also interested because if you have, for instance, a project with only partners from a number of EUREKA countries, it is possible to let other countries join as well. So if you have a partner, for instance, from China or from Taiwan or Japan, they can also join an ITEA project, and we have examples of that already in the past. What are the characteristics of ITEA? So as I mentioned, ITEA is a EUREKA cluster program for software innovation. So we are really focusing on software. There are other cluster programs in EUREKA which are on other topics like telecoms and hardware, these kind of things. And we enable an international community to collaborate in funded projects that turn innovative ideas into new businesses. So these are the two main topics for ITEA: innovation and new businesses. And of course, we want to go for economic growth and benefits in the end. ITEA is open for different kind of organization that can be large industries, SMEs, startups, academia, and also customer organizations. So we like to see normally a good ecosystem there participating in an ITEA project. And as you see, SMEs are really participating a lot in ITEA projects already. I would say even this 45% is even at the lower side now. We are now almost at 50%. The third and last characteristic I would say of ITEA is we have bottom-up project creation. That means that we do not have specific themes for our project calls. However, we allow the projects when they have an idea which is fitting within the software innovation scope to bring up their ideas to ITEA. It's very mostly industry driven, so that means that we are quite close to the market. So we are looking at customer needs. And our projects, you could say, are really close to the market at the end of a project. If you want to know more about ITEA, you see here the link to the ITEA website. There you can see examples of projects. You can find information about how to participate in ITEA. So all this information is there. Okay, next slide, please. So how can you participate in ITEA? We have each year a call for new projects, and this call is opening in the beginning of September. We start this call always with a 2-day project outline preparation day event. Each year it will be in a different city. This year it was in Amsterdam. Next year it will most probably be in Helsinki. And if you want to be notified about this, please register yourself on the ITEA website. So we will inform you when the next project outline preparation day event is taking place. It's a very lively event normally. We allow only about 300 people to come there. But it's quite soon, it's fully booked. So if you want to participate, please do not hesitate to register yourself for this event then. And it's really an interactive event, and I could say that mostly 80% of the projects which are submitted to us are really initiated in this event over there. Then the step you go through for forming a project is it's a three-step process. First of all, we ask you to submit a project outline. This is just a short overview of your project goals, the innovation, targeted business impact, and the consortium. And the project outlines, which are positively evaluated, are then invited for the second step, which is to submit a full project proposal. And in this project proposal, you also have to add the project plan, so how you are going to run your project, what is the management and the execution, of course, of this project. And approved FPPs will receive finally an ITEA label. An ITEA label is a kind of quality label, and the evaluation which has been taken place by ITEA technical experts, and on the other side also the people from the authorities, the public authorities, have evaluated your projects. So in the end, you will receive an ITEA label, which is a kind of quality label here. It is not a guarantee that you will get then also the funding, because that is the third step. There, each consortium and their partners have to go to their own national funding agencies and apply for funding there. But we have, of course, in the ITEA, in the network of EUREKA, we have the link to the public authorities there to support your funding, of course. So after this this final step, and when the funding and the approvals are done, then the projects can start. Okay, so this was in a nutshell ITEA. If you have any further question, then please come back to me afterwards. Thank you.
Thank you, Eric, for the very interesting presentation. It's a very interesting program, and I hope someone in our audience will be participating in the future. Let me introduce the second speaker for today, Mr. De Tullio, who is an Italian lawyer who practices in Bari. He's a trademark attorney, and he has more than 10 years of experience. He's running his own law firm since 2005, and he has office in Rome and Bari and New York, and also is He's an IP expert for both the Southeast Asia and the China help desk. And of course, he wrote a lot of publication on the topic, and is very knowledgeable. So I hope every one of you will give him his full attention. But before we give the floor to Elio, we will first want to launch a poll question for you. It's to set a little bit the level, to assess the level of the audience. Have you implemented any measure to protect your intellectual property in China or in SEA? Yes, in China, yes, in Southeast Asia, or no. So now the poll will be opened, and you will have more or less 60 seconds to answer, and then we will broadcast the results, and we will ask our speaker to comment them. So 1 minute has passed. Let's wait. No, we don't wait. We show the results. And we see that 50% of the people have not implemented any measure for the moment. We hope they will do in the future. 38% has done something in China, and a solid 13% has done something in Southeast Asia. So Elio, if you want to comment a little bit this result before we go into your presentation, the floor is yours.
Thank you, Marta. Thank you all. Well, the results are quite interesting. Of course, SMEs are not fully aware about possible opportunities and problems that can be happen in China and Southeast Asia. China is a more popular market, but of course, starting from now, probably that 50% will be duly informed about what to do and what to avoid in order to afford these markets. Yeah.
Okay, let's start with the presentation. Thank you.
So, can you hear me properly?
Yes, yes, we can.
So, okay, perfect. So let's start. First of all, I like to say that the protection of software in European Union, but also in China and Southeast Asia, is one of the most complicated topics in IP matters. Indeed, there are several possibilities of protection. None of them are really the only ones, and sometimes they are not effective. But let's say that in order to have exclusivity rights on your software and all the products related to artificial intelligence or customer data integration or other kind of software, even graphical user interface, you should consider to start one of the protection we are going to comment and present this morning. So the first advice is please consider that a case-by-case approach is needed in this situation. And since an international protection of patents, copyrights, trade secrets is needed as general information, so we advise you to liaise with your EU IP attorney. That will be the right people, the right counsel, in order to verify with local IP attorneys in China and Southeast Asia the best way to implement at operative level the protection in terms of type of IP necessary. As already mentioned, the possibility to protect software in China and Southeast Asia are mainly related to copyright, let's say related to the source code or other characteristic of let's say the language of the software. Patent for invention is still an exception, and it is related to algorithms, but also some artificial intelligence or customer data integration, provided that the inventive step requirement is matched. Trade secrets in some cases, and we will just mention the protection of graphical user interface through design patents. Before starting, let me say that all part of the material presented in this presentation can be found on the IP fact sheet published by the EU-China, EU-Southeast Asia IPR SME helpdesk during last year, even with the support of the network of IP experts. But I would like also to thank you, our local partners that allow us to receive really recent updates about, for instance, examination guidelines and other topics. I will mention them afterwards. Let's say that, generally speaking, copyright protects the expression of ideas and not the ideas per se. So at the end of the day, copyright does not protect the ideas underlying the software that is often the source of commercial value. But of course, it's one of the IP rights that can be used in order to protect software. Of course, it is also needed to inform third parties, inform the public that a copyright has been registered or has started using some phrases that, for instance, those included in this slide, all rights reserved, or even mentioning the date of the starting date of the protection. Generally, an author of a work owns the copyright for that work. However, when it comes to software development, copyright ownership can be more complex. And if software is created by a developer during employment, the employer usually owns the economic rights to the work, while the employee owns the right of attribution of authorship. But sometimes things are more complicated, and a local check with local expert is needed. For example, in Indonesia, the copyright for works created by an employee during employment does not automatically belong to the employer. So in these cases, a contract or a kind of written agreement is needed. So once again, please try to consult in order to have a worldwide consistent IP strategy. Consult your EU IP expert in order to understand what is the best way to carry out a proper strategy. Another way to protect software is patents. Let's say that patents for software are exceptions, and the usual requirements needed are always the three requirements needed in order to have an invention patentable. So novelty, inventive step, and industrial applicability. In these cases, in some cases, patents for software are allowed, and softwares are eligible in order to be protected through a patent application. But for instance, in the Philippines and Thailand, it is explicitly provided in IP laws that computer software programs are not patentable. On the other hand, other countries such as Singapore and Cambodia, software may be patented. Of course, please try to be updated in order to understand the latest developments in connection with legislation, jurisprudence, and practice. Let's say that for software, you can refer to the usual piece of advice related to filing, prosecution, and registration. But generally speaking, the process for patenting invention, and in particular software, can be long, and you can receive office actions or request of qualification from the local patent office in order to understand, in order to receive protection for your software. So let's say that you can use the ASEAN Patent Examination Cooperation in order to reduce the impact of inconsistent evaluation of your invention. as alternative strategy, sorry, not an alternative, but you can also, as international strategy, you can also use the Patent Cooperation Treaty for starting an international patent filing, but considering the different approach of some patent offices in Southeast Asian countries, but also the latest development of the Chinese patent office, the CNIPA, probably a local approach, so filing a national application could be the best way to use this IP tool. Of course, if you use a PCT, please remember that it can be used in all countries except Myanmar, that is not, by the way, member of Paris Convention as well. For some part of your software, you can also use trade secrets. Of course, trade secrets is not a titled right, so you cannot file an application for trade secrets. You have to start up and implement internal procedure and protocols in order to keep some documents or some part of the software secret to, for instance, employees, independent contractors, or third parties to assess and organize the access to this information only to certain person for certain circumstances, and you can also implement physical, legal, and technical measures in order to keep some information secrets. So not all parts of the software can be protected through trade secrets, and it's not easy at all, because your company should have an organization able to implement these protocols and procedures. Of course, one of the, once again, as general information, the interdependence of rights can help. So you can use these tools in a different way with a very complementary strategy, trying to properly assess timeline and also part of the software you like to protect according to local peculiarities. For instance, well, the old approach was just to approach an IP agent in order to file a patent or file a copyright or protect trade secrets, while an IP consultant is able to assess the proper strategy using all these tools in a way that the SME can start up a dynamic valorization exploitation of rights. And of course, the possibility of protection and enforcement, but also a valorization will increase in case of using interdependence of rights in a proactive way. For instance, tablet computers and smartphones contain several software, and the products are protected through all different kind of protection mentioned before. Also, graphical user interfaces are protected, sometimes through design patent. So these are a right example of interdependence of rights on specific products. Now we'll focus on China. China is starting with copyright legislation. China is member state of Berne Convention for the Protection of Literary Work. So we know that according to this Berne Convention, copyright is a right that arises automatically at the time of creation of the work. Any work published in China by a Chinese citizen automatically enjoys protection. And if the work has been published in a foreign country, it enjoys automatic protection if it is also published in China, or if the author is a national of a country that is party to international agreements in this field. So in order to proceed with a voluntary registration of copyrights, you can use you can file an application at the Copyright Protection Center of China that is part of the Copyright National Administration Center of China. Let's say that copyright registration at CPCC is absolutely suggested, since that can be a proof of paternity of these rights and also the starting date of the protection. The duration of the protection in China is 50 years after the death of the authors, and the period of protection for all the other moral rights is unlimited. So the registration procedure shall observe some steps, some requirements, and you can find here more information about them. After this process that is not very long, the registration process takes about 30 working days, you can obtain the confirmation of your registration. As to requirements, requirements are, let's say, referring to biographical details of the owner, copy of proof of the identification of the owner, some details of the software program, the date of establishment, the operating environment, the programming language used, and the substance of software that can be submitted in the two forms that we'll analyze afterwards, so ordinary deposition or exceptional deposition. In case of ordinary, the filing will consist in first and last 30 pages of source code and specification operation manual of the entirety of the documents if these have less than 60 pages. But of course, the exceptional protection, let's say, the exceptional way is advisable. In this case, you can proceed alternatively to file first and last 30 pages of source code with some portion submitted to confidentiality, or the other option you can see in this slide. Of course, you can also add additional information about identification and details of the owner of the source code. In this way, since the China copyright law clearly provides that where there is no evidence to the contrary, the citizen whose name is shown on a work shall be deemed the author of the work, this can reinforce your protection. Copyright protection in China costs between 240 and 345 euros, depending on the number of documents. But of course, since the law allows to do that, it is advisable to reveal minor parts of the software's source code by means of this exceptional filing. So you can, in this case, obscure some confidentiality areas, and you can also decide to seal some part of the document. As alternative option, you can also use the repository of the software before Notary Public in order to obtain proof of copyright ownership and, of course, the starting date of protection. In this case, in the event of infringement by third party, this deposit can be used as evidence. The patent legislation, indeed, once again, I would like to stress the fact that it is an exception. Let's say that the guidelines of examination of patents are evolving a lot in China and Southeast Asian countries. So this is why part of this presentation will mention also this kind of IPR. We already commented on the requirements for patent invention. You have also other types of patents. Utility model patent is not applied for software, so you cannot use this in order to protect software in China. But I mention ornamental design patent because sometimes you can use it according to the last guidelines, examination guidelines. You can use them in order to protect graphical user interface. The duration of protection is 20 years from the date of filing for patent for invention, 10 years for utility models, and 10 years for design patent, and the registration procedure can be carried out alternatively using the Chinese patent application or the PCT application. Once again, since this matter is quite debatable, and there is an inconsistent way to treat this subject matter in local, national patent offices, the advice is to use, if possible, national patent application, or in case using a PCT draft claims very carefully in order to reduce the impact of possible office action coming from the examiners. As to examination, CNIPA first carries out a formal preliminary examination to verify the procedural requirements of the file application, and afterwards, within 3 years from the date of the filing, the applicant must apply for a further examination on the merit of the invention to verify the existence of the requirements for the protection of the invention. So novelty, inventive step, and industrial application. So if the applicant fails to comply with this deadline without a legitimate reason, the application is deemed to have been withdrawn. Now let's start the more interesting part of this presentation, because we are going to present the examination guidelines. Let's say that 2006 examination guidelines in China states that the following are considered to be the rules and methods for mental activities under Article 25(1) of the patent law, and are excluded, expressly excluded from patentability. So pure rules and methods for mental activities, but computer programs relating only to algorithm or rule for mathematical computing rules, etc. You can see here all the mental activities that are expressly excluded from patentability, so they are not eligible for protection through patent law. Let's say at the end of the day, computer programs per se are not patentable, but it is possible for an invention that incorporates a computer program to be patentable subject matter, because there is an exception in 2006 examination guidelines that state that the computer program may be patentable if the combination of software and hardware as a whole can really improve prior art, bring about technical solution results, and constitute a complete technical solution. So following Article 2 of the patent law and Rule 21 of the implementing regulation, and application related to computer program is only the subject matter of patent protection if it constitutes a technical solution that satisfy the requirements for patentability. So novelty, it solves technical problems, use technical measure, and is capable of producing a technical effect. So if it matches with these three criteria, that can be an exception to the general rule. On November 1st, 2019, some amendments for patent examination were approved by CNIPA. They are mainly related to inventiveness or graphical user design application. There are also some other amendments related to other topic like common knowledge, inventiveness, eligibility of human embryonic stem cells, and invalidation, but we are not going to comment them. Let's say that as to examination, some of the amendments are related to the possibility for the applicant to defer the substantive examination for 1, 2, or 3 years, but also the possibility to liaise and to contact personally the examiner in order to discuss some issues related to the invention through a personal contact, a face-to-face interview or telephone interview. And moreover, some obligations put on examiners in order to carry out a proper and fair examination. So first of all, 3 steps to carry out a prior art search, a preliminary search based on information about the patent family, the applicant and the inventor, a regular search based on the technical field of the application, and finally an extended search based on similar functionalities. Even in the examination, a 3-step method shall be observed in order to evaluate inventiveness. In order to, for a Chinese examiner to determine whether a claim is inventive in view of the prior art, he will determine the closest prior art reference, determine distinguishing technical features not disclosed by the closest prior art reference and technical problems to be solved by the distinguishing technical features, and assessing whether the distinguishing features are obvious in view of another reference of the common general knowledge. And indeed, is on the common general knowledge that is focused this reform, because it is put on examiner an obligation to provide evidence when some obstacles come from the common general knowledge. Examiners, moreover, will now be required to provide to explain reasons for the objection, for an objection based on this common general knowledge. This is very important because this is an opening to possible implementation of the guidelines in terms of protection of artificial intelligence, Internet Plus, big data, and blockchain applications of software. Indeed, some proposed amendments to the guidelines for patent examination on inventions incorporating algorithmic features or business rule and method features have been submitted to the public consultation. This public consultation ended last December 11, so we will see in the next months if what are the results of the public consultation and what is the implementation of these guidelines. Indeed, according to these proposed amendments, examination shall be directed to the solution claimed, and technical features and algorithmic features or business rules shall be considered as a whole, and the patent examination shall take care of these elements. So if the claim describes technical aspects relevant to laws of nature for the resolution of a technical problem, and if a technical effect is obtained according to the laws of nature, the solution of the claim is a technical solution, so it can be patentable. And indeed, the Article 22 could be amended in a way that you can see in this slide. In terms of novelty and in terms of inventiveness, the examination of rules and methods of mental activities could be considered could be considered this aspect in a different way, and these elements can be evaluated during the substantial examination and therefore can be considered patentable. So once again, these are only proposed amendments, but they show that an implementation of the legislation and regulation, and also the evaluation of this patent application is in progress. For instance, if we try to understand the impact of these proposed amendments on some example of examination, For instance, a method for detecting falling state of a humanoid robot based on multi-sensor information, including some claims like fusing sensor information and establishing a hierarchical sensor information fusion model to realize a decision of steadiness of the humanoid robot, and using respectively forward, backward fuzzy decision system and left-right fuzzy decision system, can be as an eligible subject matter. So these algorithm features can be considered together with the related technical features, and so it can be considered to have inventive step. The same can say, for instance, for a logistic distribution method, including a dispatcher sending a notification of arrival of goods to a server through 100 logistic terminal. In this case, as you can see in this slide, this can be also an eligible subject matter. So the distinguishing feature can be the batch notification of arrival of goods to user, and it can be considered to have inventive step. I would like to thank for these examples and these updates CCPAT, our local partners in China. I will try to hurry up because we are running out of time. So just a window on apps. You can also protect apps. You can protect the software on which apps are based. You can protect, of course, also graphical user interface through design patent. In China, there is an evolving legislation and practice accordingly. But let's say, in order to understand if they can be protected in one way or in another, please carry out a preliminary search, so a state-of-art patent search or a search on copyright registered. So you can do that following your EU attorney advice. In case of violation of an app, you can use a voluntary cooperation system at Apple Store or at Google Play, and so in any case you will be required to show the evidence of your protection. So in case the registration, the copyright registration or the patent registration accordingly. Finally, we will examine Southeast Asia, protection of software in Southeast Asia. Once again, we know that copyright protection arises automatically as soon as a work is created. You can use Berne Convention also in Southeast Asian countries. There are currently 171 members, and the majority of Southeast Asian countries are members of Berne Convention, apart from Cambodia and Myanmar. Let's say that the majority of these countries can be protected through copyright. The majority of these countries have legislation in force in order to protect software through copyright, with the exception of Myanmar, Philippines, and Thailand. But at the end of this presentation, you will also find a table with some specificities related to copyright protection in all Southeast Asian countries. So our advice, once again, is to double check locally with your EU attorneys and with your local partner the possibility to protect software in Southeast Asian countries. And this is the table I was talking before. So this table is part of one of the publications issued by the EU Southeast Asian IPR SME Help Desk. And you can see that the voluntary registration is available in the majority of Southeast Asian countries, with the exception of Myanmar and Singapore and Brunei. In the majority of the countries, the duration of protection for copyright protection is 50 years, apart from Singapore, that allows 70 years of protection starting from the date of the death of the author. Although the registration is not required, once again, is highly advisable to file a copyright registration in order to prove the ownership in case this is needed to start enforcement action. The registration of copyright in Southeast Asian countries is not expensive, so you can see that official fees are not really a big deal. The only thing you should remember is that in some countries like Thailand and Malaysia, you will need to appoint local agents in order to file copyright protection at local copyright offices. If your copyright has been duly filed and registered, you can also enforce your rights. The enforcement of copyrights in Southeast Asian countries is not consistent. In some countries is not effective, but of course the proof and the evidence of this filing and any other evidence can allow you to prove your authorship, and the starting date of protection is absolutely necessary in case you like to enforce your rights. I will invite you, in order to understand and to be very updated about latest developments on protection of patentability, on protection of on software through the patent system, I would like to invite you to consult this publication published by some colleagues on the Roused magazine on August 2019. You can find an extensive overview of the latest development of patent protection of software in Southeast Asian countries. So you will see that computer software are patentable subject matter in only in some countries like Cambodia and Singapore. In Cambodia, mainly related to computer implemented invention, and in Singapore in relation to business methods. But in the other countries, they are not considered patentable subject matter. You will see that examination guidelines of patents are evolving in the majority of these countries. In some countries, the examination guidelines allow the protection of artificial intelligence, customer data integration, or computer implemented invention and software that have these characteristics. In some other countries, these kind of software solutions are partially covered by examination guidelines, like in Malaysia, in Thailand, and in Vietnam. And you will also see that in some countries like Indonesia, Malaysia, Philippines, Thailand, and Vietnam, computer software or algorithm can form part of a wider patentable invention. So at the end of the day, in practice, according to the decision taken by the local patent offices, can be patentable, can be protected with this stronger protection that is patentability. Thank you to Roused magazine to offer this overview and this very interesting article. So conclusions, let's say the usual piece of advice for SMEs in order to afford and to go to this market. Start your IP strategy before going to the market, at least 2 years before. Carry out preliminary searches, verify the possibility of protection of software as a patent that is the strongest protection in terms of eligibility, in terms of local practices and guidelines related to novelty and inventive step. Take care of your first filing, even in European Union, because the first filing is the pillar of protection. So if you are missing some parts or your claims are not drafted in a clear way, you will have this problem also in China and Southeast Asian countries. Collect all the documents, even in certificates or other documents related to software, in order to create a database with all relevant materials to be used in case of enforcement, for instance, during trade fairs or during other exhibitions. Monitor markets and competitors' behaviors, because you are the first guardian of your rights. You need to be informed and react promptly against any misuse or any infringement. Activate through your IP attorney worldwide surveillance on your rights. Monitor IP Gazette and legal actions and verify the compliance of contracts providing local legislation as applicable law. But finally, think before going. So it's always better to have a clear strategy about how to protect your IP rights in China and Southeast Asian countries. So thank you very much, and this was my last slide.
Thank you, Elio, for the presentation. We will now open the floor for the questions from the audience. We have something which is not a question, but is nice to hear. One of our member of the audience is thanking the speakers. So let me refer this to you.
Thank you.
But there is also a question. The first question is, what is the best strategy to protect software in China in terms of timeline, time frame, etc.?
Yes.
It's for Elio.
Well, this is a very complicated question, because when you have to decide how to use trade secrets, patents and copyrights, is always not easy to understand where to start and what are the timelines needed. Let's say that first of all, it's always a good behavior to keep things secrets. Because if you keep your solution, your software, your algorithms, your source code secret, you can also evolve in a different kind of protection, like patents, that after 18 months become publicly available, public, so it is published after 18 months. But if you start with divulgation, you start with publishing some parts of your invention, so you cannot go back. Then, in terms of let's say consistency between patent application and copyright, let's say registration, probably the best solution could be to file this application simultaneously, but at the end of the day, remember that the copyright is more related to the source code, and the patent application registration is more related to some specific aspect of your software, not the software per se, but those parts that can be connected, that are related with some hardware and have inventive step and novelty. So let's say patent application registration can be still considered as an exception. So I hope to manage to answer this question.
Thank you. We have another question from our audience. It's Manuel Martin. I have a couple of questions about the graphic user interface design protection. Could you provide more information or links about it? Okay, this will follow up. Also, I wish to know about escrow agreement as a way to protect software. It's halfway between copyright and trade secret. This is the question as has been posed.
I didn't catch the last, the second question.
You would like to know more about escrow agreement. It's ESCROW agreement as a way to protect software. It's halfway between copyright and trade secrets.
It's not a common practice, this escrow agreement in software, so I don't have additional information on that, but of course I can get information and let you know. At least it is not a common practice in China and Southeast Asia, according to my best knowledge. In any case, there is always the possibility to, let's say, close and bind software through agreements and through contracts. Escrow makes me think about a kind of guarantee about some transaction. So but I cannot figure out additional information. As to graphical user interface, let's say that the amendments to the guidelines for patent examination by CNIPA provided some evolution of the graphical user interface design protection, and but they are mainly related to the requirements. So what is needed in order to protect the graphical user interface in China? So for instance, it is needed one front view showing the displaying screen panel with the graphical user interface that can be sufficient for filing, or for animated graphical user interface, the applicant shall submit at least one view showing one state of the interface as the front view and other details. So at the end of the day, it's more a way to simplify the drawing requirements for GUI rather than to define, let's say, some common field in order to obtain protection in any case. Once again, it's always a case-by-case strategy. So let's say it depends on the referred graphical user interface in the specific case.
Okay, so thank you, and I think this can be our last question. Let me thank you again, our speakers for today. Let me remember to the audience that the webinar recording will be available soon on our website, and you can see on the screen all the addresses where you can find the two help desk. So thank you to the audience, and again thank you to both the speaker to taking part of this webinar today, and I hope to see you soon, and happy holidays.
Thank you, happy holidays, bye.